And there you are.
Good evening. Welcome. We're going to officially call the meeting to order for the Cleveland Community Police Commission Police Commander Committee held at the Perkins office, 3631 Perkins. Commissioner Donaldson, at this time, is there any additions to the agenda? Let's do an overview of our draft policy that we are creating for the promotions committee. Basically, we have a number of questions that we have to answer and kind of work through, such as just different legalities as well as process and procedure on who's going to do certain tasks, as well as just the general process line to move us from this point forward. Okay, so we have the first policy that we're going to review. Is it the original, like the first, or is it the one with the firm?
We already been sent this, right?
Mhm.
This version?
Yeah, you've been sent both. I'm whatever you got here. So then I'm going to yield the floor to Martin, and he can provide a quick overview of the policy so that the public can just be aware of what we have for our first version.
Thanks, Commissioner. What we're really working on with this policy is we are trying to solidify the exact process and boundaries and guidelines that we want the CPC's Police Promotions and Evaluations Committee to undergo when it reviews a candidate for a position that's articulated in the charter. So as we all know, Section 115.5 gives the commission the ability to be a part of the comment and review process for appointing somebody to a police commander or inspector general position. This really all started with the commander positions that were in front of the committee for which wards were they? Or
Yes, 4 and 1.
4 and 1. Okay, BS 4 and 1. So we really are trying to solidify this policy before we move forward with the rest of the work this committee needs to do, so we can sort of outline our framework. Now, the reason we have two different versions of the policy is because there is two tracks that we could possibly consider going down with one key difference between the two policies. That key difference between the two policies has to do with who is performing the background checks for the applicants that are applying to be reviewed by the committee. So the two different policies are drafted exactly the same, except for that fact. One version has an outside third-party firm doing the background checks. The other policy has an in-house employee, like a staff member, doing the background checks on our behalf. And there are a couple of legal considerations to make when you're deciding what direction you want to go, because, there's a lot of considerations to make when you're deciding which direction you want to go. One, you're thinking about things like capacity of the staff versus the time it takes to retain an outside firm. Also, you're thinking about, I found through some of my legal research that if you're going to contract with an outside firm to do your background checks, then you're going to subject the entire background check process to be part of the Federal Credit Reporting Act, the FCRA. And the FCRA basically says if you're contracting with an outside party to do your background checks, you have to do a bunch of things additionally, like send additional notifications, have people sign off on waivers. If we do anything wrong, it could create a way for them to sue us specifically under that act. A lot of different additional steps that we'll have to take, and obviously the vendor would be mainly responsible for adhering to those requirements if you went that route. But it's different, certainly different than if an in-house person did it on their own. So definitely wanted to bring it to the full committee to decide what is the best policy to pursue. And obviously, the policy does not just contain the policy does not just contain who's doing the background checks, the outside firm or the in-house person. It goes through pretty much the entire process from start to finish. So maybe we can go through each section by section, talk about how we're thinking that the policy should move, how the policy should be, and go from there.
So I have
Go
a
ahead.
quick question. I know it's okay.
Don't break your mic.
I'm sorry. So if we chose to do it in-house, would we still be able to do like the BCI, the federal, all those background checks? And then if we chose to outside counsel, when you mentioned the FCRC, does that include a credit check?
Yeah.
And there's no way around not having it be a credit check included?
Yeah, so through the chair to the commissioner, you can pick and choose from a background check the pieces that you want covered and the pieces you don't want covered, right? So you can choose to do that if you want it. Yeah, no problem. But it doesn't apply just to credit checks. So the FCRA covers things if we're asking somebody to do a background check on their social media, for example. The FCRA could apply if we're doing it through a third party. Okay, so the policy at the very beginning sort of summarizes how we got here. The committee's hiring process begins once it receives notification from the Cleveland Division of Police that a position requiring the commission's input has become available. We then, through the executive director, send a records request to the the Division of Police, requesting all applications, discipline files, and use of force records for the applicants. Once received, the staff reviews the documents for completeness and removes anything unfounded or overturned through the grievance or similar internal discipline appeal process. So we really are trying to focus on having the committee view things that are founded, that are still currently founded. So if somebody grieves something that's on their record and it turned out to be that the city was in the wrong for applying that discipline against them entirely, you wouldn't want that to be a reason why a commissioner is holding that against them for not receiving a promotion, right? So you want to make sure that everything that's included in the record is something that has been founded and it still remains to be something that the committee can stand on when it reviews an applicant.
So if a person is founded, results are inconclusive, we're not allowed to use that to prevent them from getting a promotion?
Through the chair, inconclusive, I think you really have to, inconclusive is
Or unfounded?
Unfounded, yeah, if it was unfounded, we wouldn't want to use it against them because they haven't been found to be not liable or guilty or whatever the term is. It's an administrative charge. It's inconclusive.
I guess I'm thinking that there maybe has been a certain amount of like disciplinary complaints against an officer. But upon investigating, can't tell if the officer did or not because it's just murky and gray. When I say inconclusive, that's what I mean, that it's not as objective as, okay, the officer didn't turn on the body camera. It's more like, okay, well, there was only 2 people here. Did the officer say this or did the officer not say that? And how you would, and us not being able to use that as a factor for them being promoted, because I think there's also something to say for, especially officers, and there has been many, many complaints and looking at legislation or policies or GPO, sometimes they can't account for every single scenario, and so there's always loopholes. But if there's a certain number of complaints, whether or not this person has been found to be guilty or have committed those disciplinary actions, it doesn't seem like we shouldn't even take that into account. Because sometimes just the fact that there's a complaint at all means there was something that happened.
Through the chair, I think we would really probably behoove us to take it on a case-by-case basis with those circumstances to evaluate and to have the staff evaluate what items inside that specific incident are conclusive in and of itself, like, or self-evident. We don't want to remove things that are self-evident because it didn't go all the way through to a final claim or something.
Okay.
But I do want to caution the committee that taking something that is an unfounded charge or an unfounded complaint and saying that's why we're not promoting you could possibly get us in a lot of trouble.
Okay.
Because we want to make sure that we're dealing with the proven facts. Some things that, even though they're inconclusive, could be self-evident. We can stand on that, but let's take it on a case-by-case basis. Does that help at all?
Yes.
Okay.
Sorry.
No problem. So we will remove items that we will remove items that are, have not been, are unfounded or have been overturned or things of that nature before turning over the documents. The executive director will share the documents inventory with the committee members to begin the preliminary scoring process. The committee from there reviews the resumes, use the force and discipline records for each candidate, and scores each candidate for the committee scoring rubric. The committee may occasionally modify the rubric, but it must always remain considerate of the promotion requirements Department of Justice has placed on the city through its acceptance of the consent decree. And you guys were pretty good about that, from what I understand from your first time around with developing the scoring rubric. Currently, we're saying that we score in areas like education, training, professional experience, discipline, accountability, community engagement, writing style, presentation, but that could always change, like we mentioned.
Through the chair, my question is just trying to get a better understanding of the scoring rubric. I know that we can change it according to this. It just has to remain considerate. But so, for example, in that paragraph taken from the consent decree, the A through H part, I know that there are parts in there that were not included in the original rubric. So what does that mean exactly? Does that mean that we would want to go back and like try to figure out what could be added to the rubric, or are we just gonna stick to the categories like education, training, professional experience? That, like, I'm trying to figure that part out.
So I would say that, so when we did the first pilot round, it was hard to, like FOT and field training sergeant, to really get those officers service. Especially this round, I'm not sure how to acquire that. So there's always room for development and growth. But I think overall, this paragraph was utilized to try to, create the rubric, but there can always be modifications.
So we will basically stick to the things that we for sure can evaluate. So like problem solving skills, I don't know. Interpersonal skills, I don't know. So I'm just saying, like, those are the things that we would just kind of leave out of the rubric.
So I think this is our first time, so it's gonna be developing and growing.
Okay.
So that would be my answer. But I think these are things that the committee can continue to think about of how to evaluate this. Maybe we feel that we can find a measure that will better measure that, or, so I think it's open, but this is what we could create based on this first time.
Okay, thank you.
And to the chair, I would also add that just because these sections are not enumerated in the policy as the main headers of the scoring rubric, that doesn't mean that they could have been included as subheaders or like smaller factors. I just included the main headers from the current scoring rubric. So, for example, maybe problem solving skills was put into the section on education and training. I don't know. I didn't go through and check it off the list, but it could be in there. Then we continue on to say, once each member of the committee has scored the applicants, the committee then meets and combines its individual scores and preliminary scoring to arrive at its top candidates, which is along our lines of what we've been doing. The top candidates will be based solely on the score results and can be a range of 3 to 5 candidates depending on the closeness of the scores and the majority vote of the committee. So this is a key portion, talking about how our top candidate results are going to be based solely on the combined score results of the original review from each committee member. And then depending on the closest of the scores, we can open the range from being 3 up to 5 candidates. Say it's a whole bunch of close people and someone just missed it by 0.5% or something. Maybe we can open it up from being 3 to 5 or 3 to 4. Feeling good about that? Okay, great. Loving it. The committee should then reach out to the top candidates to see if they're willing to participate in the background check and community interview processes. The commission's co-chairs will complete this request by communicating the committee's top candidate list to the chief of police and asking the chief to relay the information to the candidates. The communication will also include a background check waiver and a description of the process for each candidate to read and return. The committee should replace its top candidates with the next highest scorers if any of the top candidates do not wish to continue through the remainder of the committee's review process. So essentially reaching out to have them sign off on the waivers for the background check. If you don't want to participate, well, then we'll take the next person on the list that was highest in the scoring ranking and go work our way down. Go ahead.
Just going back to the 3 to 5 candidates. So we're saying 5 will be the max. Okay. So for some reason, there were 40 candidates that applied to a position. 5 will be the max. That's what we're saying. Set, right? Okay.
To get to what the I'm thinking like finals, but like a semifinal round. Okay.
Yeah, to put them through the background check. So I think the idea here is to keep the list a little limited because obviously we don't want to spend our resources if we're going to contract with somebody that's a third party or have our internal staff do an exhaustive review in terms of a background check on 40 individuals, right? And also we don't want to subject 40 individuals that just submitted an application to now have to go through a process of having a background check if they're either not top candidate or whatever. Don't want to put them through that. But yes, 5 was a number I wrote down on a piece of paper, and if you have a different number you want to propose, I'm open to any. Okay, sounds good. Background checks are important. The next step is background checks. Background checks are an important part of the committee's work in reviewing and vetting candidates for recommendations to the mayor. So all of the highlighted text that you see here is different from the other policy. How we're written in this policy, the committee contracts with the firm to perform a Federal Credit Reporting Act complaint background check for each of the preliminary scoring top candidates. The committee must only review and consider reliable matters relevant to the position. It should avoid speculation, allegations, and rumors to ensure what it considers when reviewing candidates has been thoroughly vetted for truthfulness and accuracy. To this end, the firm should review its content and eliminate items that are irrelevant to the task and duties of the position, non-severe in nature, no longer relevant due to the amount of time that has passed since the offense or conduct or completion of the candidate's sentence, or settled/dismissed. Then we have another sentence that says, the firm should continue to provide relevant, non-confidential sworn statements by candidates, even if they are related to cases that have been dismissed or settled. Additionally, the firm should include information on pending cases, but should clearly indicate that they are still pending for the committee's consideration. The firm can expand the results by incorporating content the committee brings to the committee's attention, but the committee will not directly solicit the committee's input on this matter. So this section is full of a lot of information about what we're including, what we're not including. So go ahead.
So my question is for bullet point C. How will the firm know when a lot of time has passed for an offense or?
I would say that it depends on the offense. What we could do is separate to this document, we can maybe in our discussion with the firm see what their recommendations are, or we can come up with our own hard and fast rule, but it really depends on the offense. No longer relevant due to the amount of time that passed since the offense or conduct or completion of the candidate's sentence. So do we include items that happened 30 years ago in this? The answer is yes, depending on what it was. Right? So how do we create a policy around that other than what we have written? I'm not sure. But that's a really good question.
Can we just strike that? They're no longer relevant due to the amount of time that has passed since the offense or conduct or completion of the candidate systems sentence.
Let's talk about it. Why?
Yes, sir, Michael.
Sorry, I asked if we could just altogether strike C. I think because historically, when we look at the system of policing, that notion that previous offense, especially if it has been a certain amount of time, that is something that has been a loophole, I think, for a lot of officers who unfortunately engage in inappropriate conduct, and oftentimes conduct that leads to communities of colors being harassed. And so when I think of even as recent as the officer that killed Tamir Rice, it's been almost 10, 12 years. He is still seeking employment at other agencies. However, it is very clear that although significant time has passed since that has happened, he is in no way, shape, or form a a reliable candidate to be on anybody's police force. And so I think that there are certain actions, maybe they're not that extreme, but I think there are certain actions by law enforcement that, especially once they have done it, it is over. I think, especially when we think of historically how Black men have been treated or Black women, we had a 3 strikes criminal justice system that still exists in many states where you do 3 strikes and you're out. You know, you can get very long sentences. So to not have a certain amount of standard for a law enforcement person who has chosen to go in this field, who has chosen to make certain decisions, who has chosen wrongdoing, I think in the same way that we are holding, especially communities of color accountable, we have to hold officers accountable because if anything, they are at a higher degree. And so I don't think it is fair or just, especially from a citizens and a community perspective, to allow C to be in there. That is my viewpoint.
Through the chair, I think that's a really good perspective for sure. But we can see how somebody serving their time for a sentence on something could, and then holding it against that person. I mean, it's so hard to project exactly what the context would be in a future scenario on this one. But I definitely see where you're coming from.
I'm just very passionate about this in a way that I would rather take the risk of us not including it and it be a case-by-case scenario where an officer, I don't know, maybe it was an officer who had a perfect record one time, didn't have his body cam on, and he's like, no, this isn't fair, and he like comes to us through a means of arbitration. I'm at that point that I think this in particular, because this in particular also lays a foundation, we think of federally things like qualified immunity, it lays a foundation for police unions to be able to unfortunately not hold policemen accountable and to fight for that on different police force. So in particular, I think especially from being from a community police commission and we represented the community first, this objective right here, it is too synonymous with the current system of policing. And if we're trying to change the system, I think that point in particular has to be taken out. And I would rather us go through at least a couple cycles to see how it impacts and see what the ramifications are, rather than leave that point there.
To the chair, I think my reticence with C, it feels very arbitrary. I don't know what is a relevant, what's the proper amount of time that passes. That's the part I'm not really sure about. Do we leave it open or do we set some type of time frame? But depending on what the offense was or what the case was, I don't know. I'm having some struggles with what the proper amount of time would be that would pass. I think it kind of maybe might depend on the offense. So I'm not sure if we need that there because I feel like that time frame could fluctuate depending on the person and what happened. And so if we could flush that out, I would be comfortable keeping it. But I don't know what to do with that.
Commissioner Donaldson.
To the chair, yeah, I had the same question noted here, was just curious about the amount of time that's passed. But one of the things I just thought about is like, what if we say offenses or whatever, however we want to word it, over X number of years should be evaluated on case by case basis? Like, I'm trying to figure out how we can reword it to where we're still giving, we're still allowing ourselves to review case by case, but we're not just saying no longer relevant.
I really think leaving this out gives us more flexibility to do that than actually writing something. Because again, when you look at different cases of law, when you look at police misconduct, these are the stipulations that again lays a foundation for police unions and other organizations and auxiliary groups to be able to advocate for police officers to retain their jobs, to be promoted. Because once you put something in writing and you say this is what you follow, you have to follow it. So it's not a circumstance to Attorney Martin's point. You can't speculate every single thing that an officer could possibly do. If it's not in there at all, then we can make that decision on a case by case scenario. But once you actually put that as a criteria there were to, that means that we're held accountable to that. And that means, especially the way that is worded, from a litigation mindset, it is so ambivalent that any attorney could argue that this isn't relevant. This is relevant. This is not relevant if they're representing their client. So I actually think sometimes not putting things gives us more leeway to do exactly what everybody else wants to do on this committee than actually binding ourselves by something that we put in writing.
And then to follow up to that, the other question I had was just how we determine what's irrelevant. So I think all of this kind of relates. But process questions I've had is just to make sure this is regarding this particular paragraph that we're talking about is regarding criminal checks.
Yeah, the background.
So, because background check would include criminal driving, social media, like that's what I'm trying to understand is like what exactly would.
Right, it depends on what we would have access to in terms of they would be producing to us in a search, right? The firm would be able to tell us the complete scope that they're able to do. Obviously, we can't have access to documents that aren't public records. So if you're talking about trying to find past administrative violations at a private organization, you know, that's not possible unless we were to go through some other process. So in terms of scope, I think that has to be worked out specifically with the firm. But I also did want to note on that is that don't forget, this is all stuff that's being filtered out by the firm before it comes to the committee, right? So all this talk about case-by-case basis, it'll have to be case-by-case basis for the firm to determine what it is, not for it to come to the committee, and the committee decides what's relevant and what's not, because when we start doing that, then we start biasing ourselves in case we decide it should have been excluded. Well, now we already know about it, so what's the difference? So I think you're definitely right on in saying that we need to be very specific about our guidance to the firm in terms of what we want and what we don't want. And I think it's a committee call. So if you guys are okay with removing C, or if that's your intent, then that's fine.
And just to give more context, because I know I used the example earlier of like Timothy Lawman. While he was fired by Cleveland Police, there was no criminal charges filed. So I know we're thinking of like, oh, an officer does something and they're necessarily fired. No, because there are federal laws, there are unions, there are other legislation in place to protect officers. So like in that example that I gave of literally the officer who killed Tamir Rice, while he was fired, while there was a settlement to the mother in the city, however, that officer does not have criminal charges, which is why when he keeps applying to other police forces and other jurisdictions, he is hired, and then the family of Tamir Rice finds out and they go and advocate so that the people withdraw the offer that they have given him from employment. So there are many times, like when we think of that, that's an egregious case. Just because we see it, we're like, oh, that's criminal. Every officer, even when it's wrongdoing, it is not considered always a criminal case.
So that relates to why I was asking about what type of checks are going to be included in this background check, because there are going to be things that we don't know, we're not going to be able to see. And then how are we going to be able to see that? Will that be, I mean, I guess it's kind of related to the other policy about if we did it ourselves, we would Google search, find this information on our own. But I'm just trying to understand, like, how we even become aware of everything that could potentially be in someone's history. And then the other question I was going to ask was, I'm not sure how this relates to the normal check that officers go through. So, like, are we going above and beyond when someone is just trying to get a promotion? Are we doing more than what's normally done? if someone is, applying to be a police officer, like, I'm just trying to understand that distinction as well.
Okay, to the chair, it's all great conversation. The reason we went down this road to Commissioner Nelson's point was we have to be more vigilant than the police, or what are we doing? We're just confirming their decision making. We have the ability to go as deep as we want. Now, what would a background check include? We learned from this experience already, we need a comprehensive lawsuit check, right? We should do a criminal check because you'll get that when you get hired, but some officers get convicted of crimes and while they're policing, and you wouldn't know that unless we did that. The division is not even doing a criminal check when they vet their own commanders anymore. So they may not even remember or know officers who were arrested, or that officer may have done a really good job of hiding that fact. So there is a reason for us to be as thorough as possible. Now, keep in mind, we are making a recommendation, right? So what officers can do is say, I don't want to participate in your process. And they could still end up being the commander, but we have a duty to the community to be more thorough than the division has been. So the idea is to get them to voluntarily agree to social media check, background, including criminal check, right? Social media, these firms know how to do that now. You guys went through it when you were being selected, right? You have to willingly give up your information on what social media you have and then allow access in some instances, right? But we've learned that this is all very important. So as comprehensive as we want to be, we will define that with our contract. The only other point I'll say about this is whatever you decide, I'm not even sure why we're considering the other side. Martin wanted to come and make sure that you guys made the decision, not us, right? But as the person who is currently running the shop, we don't have the capacity to do these thoroughly. We'll miss something, and then the commission will be absolutely held to account by the community when they find something that we couldn't. This staff right now does not have the ability to do thorough, comprehensive background checks on the level that I believe we need. So I don't even think we should consider not using a firm to do this. Even the city of Cleveland doesn't do their own background checks. They hire firms to do it because they don't even have the capacity to do it. So we're a small subset of that. If they're using firms to do it, why would we try to do it ourselves? It doesn't make much sense. So I really think, that's my 2 cents on the firm. I don't think we should consider it any other way. I think we should have a standing contract with a firm to do a thorough, complete investigation. And I know there are more legal requirements, but that's more on the firm. The firms that do these understand the FCRA. They handle the legal waivers, the wording in the waivers and all that stuff, right? Your responsibility will be to protect that information, and the staff will help you with that. But I don't think it adds a tremendous amount of complication because that is standard for all companies to do pretty much thorough investigations anymore these days to get people onboarded. So those are my only 2 things.
To the chair, to the executive director, the chair, I wholeheartedly agree with you. I guess my only question is, seeing how we're kind of being held up, what it seems like with budgeting grants, would this essentially be a similar process that we would have to go before city council with legislation, a budget, and not that a budget like we don't already have the money, because I know we do, but that we will have to get approval. Somebody has to sponsor legislation, put it before council, and it has to be approved before it can happen.
Depends on the cost. So
Okay.
I don't think this is going to go over $50,000 to have a standing contract. That would be an enormous amount of money to spend on background checks. Also, the other 2 things we have is there is a state cooperative buy, right? So if the state already did a bid process for a contract, and most likely they have for background checks, you do a justification saying, this has already been vetted through another government entity via the state. And we're in a co-op. I think we're in a co-op too of local governments where we can also use contracts that they vetted. So and the city most likely already has a standing contract for background checks, either through HR or whatever. So we may be able to piggyback on that to make this faster. But at the end of the day, I don't think money's a concern. Time might be a concern, but they do have people working in these positions, and we need to do this right. So
No,
that's less of a concern.
I agree. I'm just wondering, but even with all you just said, what we have in any of those scenarios, do we have to still go before council to utilize
Only
any
if
of those
it's
services?
over $50,000 for the entire contract, and I'm not certain it would be. So yes.
So I guess my question, and to throw something to consider, is how often commanders are in the positions too, because I think that would determine cost and frequency, and time. Cause even, I don't know if it's just this one, instance where we had 3 at one time. I don't know if that's something normal. Does this happen?
No, it doesn't have, we have a backlog right now. They've only changed commanders less than a dozen times in my 8 years that I can think of, right? And then again, you're bidding on a contract that says whenever you use it, it might go 2 years, right? It'll say it costs you $2,000 per commander, right? Or per background check. So you would have a set fixed price for every time you call them on for this process. You would have a standing open contract price that whenever you need it for a period of
Okay,
time.
so
right?
then in our CPC budget, we will have probably like
Yes.
10,000 set aside,
Yes,
just in
yes.
case commanders.
Yes, that is correct. So we would then trend it and say we do about 5 or 10 of these each year and put that in the permanent budget, correct?
And if it's a contract, that means they could not adjust for things like inflation,
Correct.
other security costs that sometimes come with.
And that's why they only will probably do like 2 years before you have to revisit the contract, because if their costs change, then you would renegotiate that, or the contract will say the price can be renegotiated on the 3rd year, right? So, but typically, they hold steady for a consistent period with things like this, so.
So I guess we can return to item C, to see if this is something that we feel that we should see about the contract, or if it's given to staff, depending on how things go.
I say remove C altogether.
I guess you gotta put a motion.
I move to eliminate C because I think it jeopardizes our stance as a community police commission. And that it allows way too many loopholes in order for, unfortunately, for lack of a better term, bad police to stay on the firm and get promoted.
Is it a second?
I'm gonna second because I wanna.
Have a discussion, okay?
Yes, I understand the motion to strike it. I guess like the first part where it says no longer relevant due to the amount of time, my concern with that is that, in due to their union contracts, the police are required, like they have a smaller, I would say a lower standard, but their procedure is like keeping 3 years of records, right? So kind of on Commissioner Garrett Ferguson's point, if something were to come to court, the ambiguity of that language could become a problem. Because in the police's eyes, I think they're going to say like 3 years is enough. I don't know. If we're going to say amount of time, I feel like we should define what that amount of time is. But I also believe that I don't think that we can. Like, I'm not sure if we can actually do that. And then I get the whole idea of like if they completed their sentence, because that's how the due process should work, right? Like you were found liable for something, you served your sentence, you should be able to go back to doing, you paid your due. I don't know. I can't get myself in a position where I'm okay with it as it stands.
For
I'm
context,
struggling with it.
again,
Yeah.
look at that. Timothy
Yeah.
Noble, it has been 10 years.
Yep, I'm familiar with
He
that.
is still fired from every police force that he's applied to. So what I'm saying is, I hear you about the union, but there has not been a union in this country that has been able to advocate or to maintain that he can be an actual law enforcement officer. So I think, again, with this one, I don't think it is a matter of what police union says. I think we have to stand on why we are a community police commission the flaws of police unions, the flaws of qualified immunity, the flaws that have resulted in us having a consent decree. And if we're not thinking about it from that standpoint, I think we're taking the wrong stance.
To the commissioner through the chair, I want to clarify, when I mention a union, what I'm saying is, like, for example, they are required to keep only 3 years of records on officers. That's what I'm saying. So if something like this were to become legal, what's relevant time frame for them is going to be 3 years. That's the point that I'm making, is that you made a point earlier about how this would be problematic if it went to court. I'm agreeing with you, because I think that you're going to have a debate over what's the relevant amount of time.
Okay.
And that's all. So I wasn't making any other statement other than that, because in the way that their contracts are written, they're only required to do 3 years of record. So they could come to court and say, we think 3 years is a relevant amount of time. They've done nothing in 3 years. So that's why I would say I'm struggling with the time piece of it. Because I think this opens us up to a debate over what a relevant amount of time is. And if that's their standard, I think that's what they'll argue. And that's probably thinking too far ahead, maybe overthinking, put the cart before the horse. But that's my concern about C. I get the spirit of it. I think the spirit of it to me is to be fair, right? And to not misjudge people or consider things that may not be fair to them. I think that's how I read the spirit of it, but I'm not really sure. One, I don't think we can just put a number out there, but I'm not really sure what it would be based on. We put this many years, but who would say it's this many years? I get it. I'm open to rewriting it, but I'm also open to eliminating it if we cannot rewrite it.
I just want to make sure we're remember, this is for the firm to take it out. So in this instance, if you wanted to do the determination made by the commission if it's relevant or not, what you'd want to do is eliminate it here. I would agree with that, because you're allowing the firm to block things from you seeing it at this point, right? And determine what's relevant and how much time has passed. It doesn't mean you can't ask them to pass through and then you all determine if it's relevant or if it's too much time has passed, right? So this is a matter of who determines how, what you see. Do you want to see it all, or do you want the firm to screen it so that you only see things based on that C provision, right? So I think that's an important distinction here, is if you want the right to make that determination if time has passed or if the offense or conduct, or if the sentence is relevant, that's something that you need to move through to you and remove this. If you don't, if you trust the firm to make that determination for you, then keep it. So I think that's the thing, is we're forgetting we're at the firm stage a little bit here, but you won't see it unless you agree now that the firm has to pass it through to you to consider.
So I think probably rewriting it would say maybe candidate history would be provided and the committee will determine. I don't know. I was just,
So that's the hard part, is that, to the chair, that's the hard part,
Yeah.
is the committee can't, if we start providing this information to the committee, we're defeating the purpose of the policy.
so they would have to determine,
The firm would be the one that would be determining.
right? So even if you took this out, they would still determine it.
No, they wouldn't. They would just give us a full record.
They would give you the full record of what they found. What you could say is that the firm would work with the executive director's team or people that are not on the committee.
I would,
Oh,
yeah.
You know what I mean?
yeah,
I mean, you could get.
because the point is for us not to see it, so we won't be buying it. So
Exactly.
that might be
I
the
think
best
I-
option.
No, we should see it. I don't understand why we wouldn't see it.
To the chair, it's we're going. So the firm is already automatically going to screen out. So it's in here. I'm fairly certain, having not read it for a while. Anything that it's unlawful for you to see, right? So you're safe there. So now these are things that are subjective for you to see, right? And we're asking, do you want additional things to be screen that are subjective, right? So long as the firm does its due diligence, and this is why you need a firm, right? To say, well, this absolutely shouldn't go because it's unlawful for you to look at that, or you shouldn't consider this under, equal employment opportunity or whatever. That's great to have that extra blanket, right? These are all subjective things that you're putting on the firm, right, to decide,
So the
right?
through
Remark
the chair to the executive director, I wouldn't say that's 100% true. There are some items in here that if they saw these things and made decisions based on them, they could be unlawful. So items like irrelevant to tasks and duties of the position. If we make a decision that we don't want to give somebody a job because they are not good at seesaw, then we could get in a lot of trouble for that, right? I mean, it's not saying that these are all optional, but I believe that we have something to stand on if we wanted to go down Commissioner Garrett Ferguson's line of thinking of saying, look, I understand why C would exist, but if we really believe in this specific context of community policing and promoting police officers in general, that almost 100% of the time, their entire history is relevant, always relevant.
Okay, so going along the lines of what you said, their history is always relevant. But it seems like if there's things not related to the position.
No, that's what I'm saying. I was speaking specifically in terms of time, not of substance.
Oh,
So
okay.
this is saying they're no longer relevant because amount of time has passed or they've served their sentence, right? So this C is limiting just to a time scenario from the offense. They're obviously,
But they're still, okay.
right, if it was irrelevant, yeah, to the duties, yes.
To the chair, is there a way to amend this in a way, I guess, like, as we're talking, then the question in my mind is, whoever this firm would be, because I'm assuming that this would be a firm that would do these type of searches for multiple types of groups and organizations, right? So my question would be, if they will have the knowledge of this policing stuff to be able to make those decisions as to whether or not it's relevant or not. And so I would be more comfortable if somehow, some way, that information that they may not be sure about, or could they just give it to like our staff? And then I would feel more comfortable with you making a determination if it was relevant to it or not. But I know we're trying to shield ourselves from being biased and things like that. But then I'm also, we're now a year and a half into this work, and it's taken us a while to really learn, the nuts and bolts of this work. And I would be concerned about if maybe something would be dismissed that maybe doesn't need to be dismissed.
With all due respect, I think we're way too concerned, one, with whether or not we're going to be seen as biased. Our job, numero uno, is to represent the community. And right now, it sounds like we are passing off our responsibility first to the firm and then to our staff. If it is something that is egregious, there is no reason why we should not access or have knowledge of every single thing within that record. It's asking someone else to filter. It eliminates the need for a community police commission, even with the staff. It eliminates why we could be appointed. Because if that's the case, they couldn't have us and they could just have a staff in the office and say, hey, you guys look at this. But we were hired to add a certain level of scrutiny because we represent community, because we are biased. We do think differently. And there's nothing wrong with that. And I think we have spent too much time, which is why we're a year and a half in and haven't done certain things, because we're so busy trying to not seem biased when the whole point of why we are here is to represent community, is to bring our lived perspectives, our lived lives in, and look at things from that lens. That is a level of bias, but we also are protected under that.
But being for to the chair, but we do have to be fair. We cannot look
Being
like, no, we have to be fair.
Especially
Part
hiring.
of serving the community is being fair. We have to be
Part
fair.
of hiring the community is making sure that we do not hire incompetent
I
officers
think we're,
who
But we're
have
not in
done
charge,
things.
so let's be clear that we're not hiring, we're providing a
We're
recommendation. So I'm not saying that our recommendation should be,
If we haven't seen the full
Haphazard.
record and we are,
it should be
because
haphazard.
this is what I'm saying. If you are leaving it up to a firm or our staff, and this is no disrespect, you don't know the political ideology of those people. Just because a firm has experience, because I think that's what I'm saying. I think too many of us have licensures and we are actually believing that in these firms that there are certain just like, guidelines they have to file where there are not, you have firms.
So I'm gonna bring it back. So
Hire.
as a committee, we have two policies that we have the ability to review, one with a firm and one without. So
I'm not arguing for the firm, Adriana. What I'm saying is when it comes to C, allowing that to be filtered through the eyes of a firm, that in particular, before we see it, if we're just like, the firm will let us know, we do not know the political ideology of that firm. So that it's like, I think because so many of us have licensures that are on here, we look at things in a very legalistic way, that if the firm was withholding information that they should tell us, that it will be on them and we could like sue or have arbitration. When the actual facts is, if there are two firms that both do this type of work, you have one firm that could be progressive, you have one firm that could be conservative. It is not against the law if we have C in there for them to make a decision not to tell us about a cop who killed somebody 20 years ago. That is not going to be illegal for that conservative firm. Just like it is not illegal if a progressive firm said 20 years ago a cop didn't turn on a body cam or a cop was late and I don't think you should do it. Neither one of those scenarios that's not a legalistic thing. So we are putting the responsibility that we have been entrusted to by the voters in the hands of a firm. When it comes to C, I believe that we should have a firm. I said when it comes to C, that is too subjective to allow a firm or our staff to make a determination on whether or not we get the information. We strike it. We get all the information when it comes to C, and then we move forward.
So I hear you. People might feel differently. I think it could be rewarded, but that's my stance. But I don't know where everybody else stands. We hear your points. Is there any other thing anybody would like to add?
Through the show, the only thing I was gonna add was, thinking forward, depending on whatever information we receive, we'll have to also think about, how we're gonna determine what's relevant, not relevant. So there would need to be some sort of list, like matrix or something put together, because we don't want to get into the situation where we're like, oh, well, this is fine, but no, that's not fine.
Any
And then,
subjective?
you know, and then we're coming across situations where we might have said something wasn't relevant in one case, but it is relevant in another case. And like, that's the thing that I'm thinking about, is like, once we do get information, how are we going to determine what's relevant, what's not relevant, the amount of time? Was it 15 years ago? Was it 2 years ago? Was it like, that's the thing that we have to think through as well.
And I think this, we're working through this. I think these are all great points and interesting comments. The answer is we're working through it. We don't have an answer yet, right? So hopefully, if we go with this option, we can fine tune that and maybe have some discussions. And I think it's really important who we select as a firm too, because that matters, right? And asking those questions during the interviews of whoever we select, right? To see their position and their perspective if we decide this option.
Do you want to put a pin in this exact C section? And so we can continue working the policy, and if we have time, come back to it. Because I do think if we advance a policy, it should be reflective of the majority of the quorum, right? So,
There's a motion on the floor to strike C, so
Right.
it would have to be withdrawn or call for a vote.
I'm not withdrawing, so we can
Okay.
call it for a vote.
So we're gonna call for the vote. Commissioner Adams?
well, is he a member of the committee? No, he's not another.
Because Kyle, we're not below 3 right now because Commissioner Early is technically still on, so he can participate in discussion, but he can't vote.
Commissioner Donaldson,
Aye.
Commissioner Gary Ferguson,
I,
Commissioner Rodriguez. I'm gonna say no.
Okay.
Motion passes.
So C is struck.
All right, figured it out now. Perfect. Okay, I think we continue to do this part. The firm should continue to provide relevant sworn statements by candidates, even if they are related to cases that have been dismissed or settled. Additionally, the firm should include information on pending cases, but should clearly indicate that they are still pending for the committee's consideration. The firm can expand the results by incorporating content the community brings to the committee's attention, but the committee will not directly solicit the community's input on this matter. Next section. Additionally, the firm should remove anything from the search results that identify an applicant's protected class, like race, color, religion, sex, including pregnancy, sexual orientation, or gender identity, national origin, age 4 or older, disability, and genetic information, including family medical history. Final results. The executive director should review the information from the background check firm and confirm it conforms to the standards articulated in this policy. The executive director should then communicate the information to the committee, which will then meet and decide on final candidates for the committee interview. The committee may modify or exclude candidates from its top candidate list based on the background information by scoring the results against a background check scoring sheet. Background check scoring sheet should contain a grading system where committee members can score the severity of search results against direct links to the position's job description. The committee should keep thresholds consistent for all candidates and review the information fairly and in an unbiased manner. The committee must never eliminate a candidate in a manner that would violate federal, state, or local regulations, including but not limited to Title VII of the Civil Rights Act of 1964, Family Medical Leave Act, or the Americans with Disabilities Act of 1990 as amended. Specifically, the committee is prohibited from not hiring a candidate based on the fact that the candidate made a protected action. Protected actions include but are not limited to filing or being a witness in an EEO charge, communicating with superior, supervisor, or manager about employment discrimination or harassment, answering questions during an employer investigation of alleged harassment, refusing to follow orders that would result in discrimination, resisting sexual advances or intervening to protect others, requesting accommodation of a disability religious practice, or asking managers or coworkers about salary information to uncover potentially discriminatory wages. Step 3, community interview. Final step is for the community to interview its remaining top candidates during a live event with the community. The event is an opportunity for residents to get to know the candidates and be directly involved in the hiring process that selects a candidate who will lead policing in their neighborhood. The committee will coordinate the schedules of the candidates willing to attend the event, select the location, and advertise it to the general public. Again, the committee must ensure all questions asked of the candidates are compliant with federal, state, and local regulations, including but not limited to those things I listed before. Prohibited questions. A non-exhaustive list of prohibited questions include, here's a whole long list of questions that we are not asking the candidates. And these are, of course, just examples. There are other questions of a similar nature that we should not be asking or have asked of them.
Huh.
So you're gonna get sued for that.
Yeah. These are not great questions to be asking.
question,
Yes.
the one about regional accommodations, how, or is it up to them, because I'm thinking about like the EOC or people with different abilities that apply. Should they be the ones, like once they disclose, they are the ones that says, I'm thinking about like job applications and it's like if you need accommodations, like please reach out to so-and-so. So I was just wondering about that, like is it not on our onus to ask it, we put that disclaimer, and then they bring it to us, or how does that work?
So how it works is that really it's a question that we don't ask during the application and like interview phase. That's a question about what your actual accommodations are that you need to perform the job. It's something that you're asking like, okay, your first day is this, how can we get you ready? You know,
Gotcha,
sort of
okay.
level. So it's just not at our stage.
Okay,
And it could be, you know, discriminatory to be asking at our stage.
gotcha, okay.
Through the chair, I just had a question about the community involvement, because reading through this, it seems to me that the community is only involved if they maybe submit questions that we select to be asked during the community interview process. And I just want to make sure I'm clear on that, because it states, about this event is opportunity for residents to be directly involved, and then it states earlier how community feedback is going to be considered. But thinking through the process, we can't directly solicit information. Anything that's provided to us, we have to, I guess, maybe in regards to the background check, take that to the firm in some cases. But what I'm basically saying is, it seems like the community is only involved in this entire process through questions. So it seems like it's really us having a public meeting, interviewing the candidates, and then the community members can be present, because we also don't have a public comment section either. So I'm just trying to, and the reason why I'm just bringing this up is because I'm trying to think through how we're really involving the community, because we're also not considering things that they might bring to us when we make our decisions. We're not doing that either, the way it's written further on. So I'm just kind of trying to better understand community involvement overall.
So through the chair, I'm so glad you asked that question, because that's something that we were struggling with a lot while thinking through this process. We want to involve the community as much as we can, because like we said in the preamble of this section, we are trying to get them involved in the process that selects the commander that's going to be leading policing in their neighborhood, right? But at the same exact time, we can't open up the microphone to a bunch of people that are going to ask extremely problematic questions and bias the whole process. So the proposal that we have, I believe, on the table before us is a hybrid of that. They are still involved because they are submitting questions that they would like to see asked to the committee before the event, and then we can review those questions and finalize the questions before they are asked at the event. So, I could perceive of an instance where we have a whole bunch of really good questions submitted by community members, and we say, this one was asked by Rebecca from East 152nd Street or whatever. That could be a perfectly fine question, but we definitely have to make sure that we're filtering questions so that we don't put ourselves and the city at risk for liability purposes. And we are having still a feedback thing, right? I think that this policy has some sort of feedback function in it. It's not asking, I think in our first commander meeting, we said we weren't going to ask specifically, rate your number one candidate. I think there was an American Idol sort of reference. But there is, I think there is still a community survey that we're asking at the event.
Yes, and then another question I had was about that, because it says factor in any community feedback it receives, but how are we going to validate that feedback? We don't really know what someone would say or think. So I don't know. It just seems to me that we're not really, we're involved in the community, but I think that we just have to be really transparent once this process kicks off to the community on what exactly their involvement will be and what we are able to incorporate and what we're not going to incorporate into our decision. Because what I wouldn't want to happen is for us to get to the end of this process, make a recommendation, and then you have 50 plus community members saying, well, we told you all about X, Y, and Z, but you didn't incorporate that because of maybe we couldn't, just those are the things I'm trying to think about.
And to the chair, to the commissioner, through the chair, I think that's just the reality of it, right? We can't take every single thing that's thrown at us and say, this is what we are holding our hat on, because there needs to be a filter in this process. Or we're going to open ourselves up to liability. It's just the reality of it. So as we work through it, if there are ways in your mind that you can think of improving what we've already written that could possibly work to fit in that framework, I am very open to those suggestions. But I want to make sure we're safe.
And to the chair, through the chair, Commissioner Allison, I think the idea was still to have a community event around this, correct?
Yeah.
So at the end of the day, when you do your open public comment period, if 7 out of 10 people who speak say, we just don't like this person, right? And it's not, you are allowed to consider community overall impression, right? So long as it doesn't fit into that discriminatory class, or they didn't introduce something into your mind that biased that decision, right? So if the community sentiment is just no on a person, right? And you can articulate that the community just doesn't agree, and you make that part of your scoring rubric and saying, did the community feel like, this person was somebody that they would accept? You can find a way to score that in the rubric, so long as it's not discriminatory, right? Because overall sentiment does matter, right? It does matter. If you're in the district, in the 4th district, and you hear the majority of people come to the microphone and say, not this person, right? And they're not specific, and they're not like because of discriminatory reason, you can consider that, right? Their opinion does matter in this. So if you work that into the rubric, community comment or community sentiment, it is acceptable, as long as it's not discriminatory.
To the chair, so maybe, would it be possible, because I hear Commissioner Johnson's point about at what point, is the community really involved, but then I went back and looked, I'm like, well, we're scoring, and then we're doing the background check, and we're scoring. I don't know where they come in before the interview, but would it be it's something we should do to sort of encourage the community to speak earlier in the process? I mean, should we announce like the CPC is considering the following officers for the commander position and just put it out there? And if people have something to say, they could put it out there earlier. I don't know, but
So the way
like
the
I don't know how
policy
we
is
would.
written is supposed to be a meeting. So before we actually have the community event, all our documents from everything from the background search to what we use is all going to be posted so that they can have that information too. So that's my
No, I'm talking
understanding
about
when I read
before
the
that.
policy.
I'm talking about, say, District 2 opens up, and I'm saying we have 15 people that apply. Do we just announce these 15 people applied? And if the community members have a voice, to say something, they could do it then before we ever. I'm just saying, I'm trying to figure out how to get more community voice in, but I don't know how else to get it in this process before you get the interviews.
So let me give you an example, right? So when I've seen these done in the past, when you're doing the interview in front of the community, right, and you have 50 people sitting there watching the interview, at the end of that, if you have a public comment period and they really didn't like an answer, right, the community will tell you, like, that answer was way off the mark, right? Like, we don't agree with that answer, we don't like that answer, whatever it may be, right? So you can disregard that or you can listen to it, but it is involving the community, right? They are saying how they felt about that interview process if you give them an opportunity to speak on what they observed during that interview. So, how you work that into your rubric, that's up to you all, right? But I would certainly not leave community comment off of the rubric in any way, right? You would definitely want community feedback to filter in there, again, so long as it doesn't violate that person's protected
And
area.
through the chair to the executive director, our current policy is, we haven't gotten there yet, but Commissioner Donaldson alluded to it. Our current policy does not allow for public comment at the actual public interview. What it allows for is feedback to be received on survey forms. So it's different than opening up a microphone for someone to say whatever they want to say and asking whatever they want to ask.
And to the chair, I don't think we're saying ask questions, right? This is like any other meeting where we go through a meeting and we don't have to respond to what the community says in real time. They're not asking the interviewee questions. They may be asking the commission questions, but the commission doesn't have to respond. But I don't think you should exclude listening to the feedback of what they just witnessed at the end of that experience. So they should be allowed to give you their feedback on what they observed.
So I guess the question becomes, how do maybe I say something and you don't want it to influence everybody else, right? In a good or a bad way. So I guess that's where I understand what you're saying, but I guess that's my concern.
If we're doing it only in writing, we're excluding a portion of the community. We've learned from the past, like if you just do the write down or fill out a form online, like a lot of people, their best way for providing feedback to you is that microphone. Their only way to provide that feedback to you sometimes is the microphone that they're comfortable with. So while I encourage the, yes, fill out forms and give us your feedback, right? I definitely would say, I'm not certain if we want to cut at the end of that interview, letting people just process what they just witnessed and give you their opinions, right? It's just their opinion. It doesn't mean you have to utilize that opinion, but how else are you hearing the community in this?
So I think you can hear without it. I think, okay, so let's just say we understand that Cleveland has literacy issues. Maybe they could talk to their staff, and if you need help writing it down, and I can still hear you. But I think I got concerned of people saying like, maybe an experience or something that may infect the rest of the audience, especially if we're gonna take that input.
To the chair, I have some concerns about us again being community police commission and then wanting to censor community. It to a certain extent, and I think maybe because especially starting out in the beginning, and I know myself included, it has been a very tough 2 years, and we have, had to deal with a lot of public scrutiny and a lot of outbursts and different things from community. However, it is not good governance to censor or to try to control what the public says. I understand that we live in a community where guidelines have been put in place at the city and county level to somehow try to control that. But if we are actually people from the community, and while it may be very hard for us, and we got through it those 2 years, I think we have to be willing to allow community members to process information and state their opinions however they may be. We have done, I think, a great due diligence, and it seems for one of the last meetings I went to, law enforcement was here. So I think if it is elevated, of course, to a point of violence and threats, that's one thing. But while we may not want to hear, I think it's important for us to hear. I also think that, yes, some of the things that community can say can influence a decision. I don't necessarily think that's a bad thing because, again, I think we're trying too much to be an extension of law enforcement and not enough of a separate body that has been tasked with a very hard job of taking all these opinions in and filtering through. So I would not want to require people to write anything down. I think it could be an option for people. I think a survey is an option, but I also think we need to be willing to hear the raw emotions and comments, especially as a person who has done lobbying and have done public comment in every sector of government. And other states of government, they don't really censor you. Like, you get up there, you have 3 minutes, but you say whatever you want to say. And of course, there's like a bailiff or security that if you threaten, you're removed. But I've been part of state house protests where they definitely did not like the things that we were saying to them. We were not removed. They had to sit there and take it as part of being a public servant. And so I don't think that we're above any of the actual elected officials. So we should listen.
So I do agree with that. I also understand that this is a job interview, and I think in general, just for any job interview I've been through, there are certain things that transpire and take place. So it's not really censoring you. Just like I'm a person and I go through interviews, there are certain things that I am protected from, and I do agree, like, we uphold community, but I also think that we have this very unique task, right? And when you go to interviews, there are a certain standard, and there is some levels of protocols, right? And processes in place. So while I do understand, I'm not trying to limit free speech. I'm not trying to impose on anyone. In my opinion, and in my view, we have to ensure that we uphold community while also protecting the responsibility that we have. We can't have an interview where, even in the instance that there is, I may believe or perceive something, I have to ensure that we uphold certain like legalities, and that's the reality of it. So it's an intricate balance between how do we, of course, we're going to protect community, but also ensure that this task, that if we don't do it a certain way, it's a possibility that we won't be able to have it, and that's the reality.
I understand. I also would like to understand, maybe Martin can answer this, because compared to any of our positions, we're not law enforcement and we're not a commander. And that is a public, so from my understanding, that there is a certain level of public scrutiny that cannot be compared to people who are civilians. And I think not civilians, but on the sense of in the private sector, because they are representing an entire district of policing. Is a very public job. And so I would like even to understand, maybe Attorney Martin can explain more, what legalities exist from allowing the public to express feelings at either the end of that event or the end of that interview process. What are the legalities that remain? Because from my knowledge, there isn't explicit legalities.
I just want to say really quickly, I don't know if that's the issue. I think it's not about if it's legal for them to make the comments that they want to make or not. I think that we, like Commissioner Rodriguez says, like the public can say whatever they want to say, however they want to say it, to whoever they want to say it to. We can't do that. We have to create a space where we don't look biased. We cannot look biased, whether we all know the research that says that everyone has some sort of bias. But when it comes to this work, that cannot be the rule. We're just going to say, oh, we're all biased and everybody. I think that what we're trying to do is have a balance between making sure that we do have the voice of the community and what they think out there, but also do that in a way that doesn't compromise this process, in a way that it completely invalidates it and undermines it. And I think that that's what we're struggling with, is we're trying to figure out, well, how do we allow them to speak? I mean, you could have a scenario where someone could be lying, someone could just have an axe to grind, someone could be completely wrong, they can be a great orator and very persuasive, and now we've allowed this to get out there. Now the whole audience and community is getting behind this person. The stuff that they're saying is not true. And now we're in a position where we can't make a fair and unbiased choice because now we're getting pressure from the community over something that is not even proven or may not even be true. I just think I hear everything you're saying, but we're trying to find a balance. But we are held to a different standard. Like the community is, in the end, they're not going to be the ones that are going to make the recommendation. We're going to be the ones that make the recommendation. And then we already know from what we're already seeing, everything that we use to make this decision is probably going to be requested through a public record anyway. So we have to make sure that everything is done as properly as possible, because one way or another, those records and the things that we use to make this decision, and they're going to be requested. And what we don't need is, we don't need to be influenced, because we're people. You get influence. Like, I'm sorry, no matter who you are, big crowds and groups can influence people. I just want to say that I hear everything you're saying. But I just feel like we're trying to find that balance between being fair and balanced, but also trying to hear what the community has to say.
And I think we are overstepping ourselves as public servants, because when I think of every single public, interview process, appointment process, while it's not always the public, there's always a level of scrutiny in which there are questions that are asked that are often that present a sense of bias that doesn't always make sense. I think that is welcome to American politics. I think us having our responsibility comes in, we are the truth finders, we are the fact finders. and we are the fact checkers. So if we have someone, they can get up here and say that this officer believes the color blue is green. Okay, and the community can be roaring and cheering. We still make a decision to put that officer forward. In doing so, we also have the responsibility to justify. But while we understand that the community felt that what this officer said was true, through our research, because as you said, they are going to do a public records request no matter what. We have found that this officer is the best candidate based on A, B, and C. But I do not know any government body, especially in the current state of politics that we are in, where people were not opened up to public scrutiny, where you didn't even have, because this is another thing, we don't have to let the public speak, but one of us could take all of the questions, all of the concerns and the comments from the public, and then we say it that day. Because that also happens. So I think of people like, I don't know, Ketanji Brown, and how she was treated when she went before the Supreme Court, and she was asked very egregious questions. Like, it is very common, especially in our political stance, that there is going to be a messy, unfortunately, it's going to sometimes be a messy question and answer, especially when we're talking about police officers in positions of authority in a city that has been a consent decree for 10 years now? So I don't think we can control every single optic. I think the crowd control comes in. We have law enforcement here. You can say people can only speak for 3 to 4 minutes. Whatever decision we make, we justify it. We can put it out there in writing. But I don't think we censor people's lived experience. Because who's to say what someone is saying is a lie?
I didn't say it was.
I mean, but who's to say someone is lying? Because my truth is my truth and your truth is your truth. Okay.
I'm not here to, but we're not here for that, right?
People-
We're not here to confirm or deny. I agree.
But Chair, can I make some logistical points just to put it in context? So, 2 things. One is, you can't be held liable because you're not allowing them to ask questions, in my opinion, right? You're not allowing them to ask questions directly to candidates, so you're not involving them in your questioning process. So they can't ask the candidate an illegal question, right? If they stood up and they told a complete lie against someone, that officer can address that civilly, right? So if that officer feels they were wronged by a community member who lied,
I don't think.
hold on 1 second. And we're talking about it in a strange context because we already decided we're having public comment at officer hearings, right? So if you're worried about public comment influencing your decisions, that was discussed already in our hearing procedures, and we decided that it was essential to have public comment during a hearing over someone's employment, whether we're firing them or demoting them or whatever it may be, right? So if we allow public comment in that, there's really no difference here. All we're doing is listening. We have no obligation to make a decision or to Commissioner Garrett Fergus's point on that. But in my experience, you would be making a mistake not letting this community speak at the end of a community interview and just give you feedback on what they observed. It's that simple. You don't have to act on that feedback. You already did a background check, right? So you know what is a lie and what is the truth. You should have discovered it already. Like, it's very unlikely that they would bring some information unless it was a personal story. Somebody stood up at the microphone and said, you know, this officer came to my house and you're not going to find that in your background check. But I did not have a positive experience with this officer. They have the right to tell you that. Like, you don't have to consider it, right? But that is the point of a community interview. And I really think you're going to get some blowback on this if you don't allow the community to speak at the end. You had a very robust discussion on why you're allowing that during the hearing procedures, right? And when it is appropriate, either at the front or the back end, and you chose to allow it both at the front and the back end of the hearing so that people can decompress what they felt about the hearing at the end. It's the same. You know, if you want to make do your scoring before the public comment, that insulates you even more. So you can score in real time, right? You can then evaluate your scores in real time and then announce your results and then let the public speak. That way it can influence you. But I'm not seeing, you know, as much as we worry about the specter of litigation, I think we're really overthinking it in this instance just to hear the public on a microphone give you an opinion. Because it is ultimately the animus if you choose to use a lie or a discriminatory bias. that's you anyway. That's not because the public, you have control over that. They can't make you do that. So if someone ever had a case against you for discrimination, you know, because you heard a public opinion, that was going to be something they were gonna say anyway. So I really think it doesn't cost you anything to allow the public to do this. And my experience as the executive director is we should let them, say how they feel about these candidates, you know.
That's not my point. I don't disagree with that. My point is, now we're saying several things. The community, if they're really against somebody, then we should consider that, right? But what if the things that they're considering or the things that have helped them determine that they're against the person is something that's said in real time that we can't fact check? We don't know if it's true. And we're going to make a decision. That was my only point. My only point is that if what we're going to do is really listen to the community, and if, like you said, we can factor it in, and it maybe should be represented in a rubric or something. But if the community is making its opposition or its support based on something that we can't check, then that's my concern. My concern is not with the community having a voice. My concern is with how a person or persons could sway the community in that room, and now they're on us to make a certain decision. And then we then say, even though this is what you guys are telling us, we're still going to do this. They're gonna feel like they're not being listened to. Like, that's like my concern. I don't have a concern about letting people talk. We do it all the time. People come to our meetings, they say lots of things about us, and we sit there and we listen. But that's like, there's another dimension of this where we're supposed to consider what the community is saying. And if they're all saying one thing and then we do a different thing, then we look like we didn't listen to them.
We're not making the final decision that day, though. So if people, at the end of the interview, we're not saying this is the person that's going to be the commander. So people can say whatever they want. We can fact check in the next days that we are literally making the decision. And I think also, I'm sorry, we have a responsibility. If we do not have the common sense, or we don't have the wisdom or the ability to take what a person is saying and internalize it and really critically think about it over a couple days before we make a decision, and we shouldn't be commissioners.
Well, what I'm gonna say is,
Like, I'm being honest, we shouldn't.
nothing on this commission takes a couple days.
Well,
I'm
okay,
just
so
saying.
if it doesn't take
I'm
a couple
just saying.
days, I'm saying, so if it doesn't take a couple days, if somebody is saying something and it's a personal story and we never heard it, and maybe we think it's true, maybe we don't, I truly believe that us as a committee, us as a commission, will walk away that night like, wow, that person said something. Let's think about this. Is there a way to find out more information about this? Maybe we should just stick to what we already knew. I don't think there is any wrongdoing in letting them speak, because again, when we say that these are our people, we can justify it because we still did a very unbiased, empirical analysis of each and every person. And you can still look into, so if a woman gets up here and says, this officer pulled me over and came to my house last night, that tomorrow morning I can like call whatever district and say, did officer so-and-so come, is there any record, is there any of it?
But so I guess this is where I come in, because the way I see it, let's just say that community member had a very valid complaint. That's when you will go to OPS or IA. I don't even think we can take that information. Let's just say it's valid. I don't
Yes,
think
you
anybody.
can. You can't take the information and just call. We did it. What was it, the meeting we were at First
But depending
District,
on what they say,
when
I
the
can't
lady
say.
was acting, where she started yelling and screaming. I don't remember her name, and she was taken out of, was at Community Harvest Center. She was removed, right? You, because I talked to you after.
I was in Seattle. I mean, I was in Philly.
No, you were there because after the meeting, you sent an email. Me and you talked, and you sent the email to the commander who was there and said, I just want to know what happened to that woman, because she got on the mic and said a litany of things that had just happened to her. And all you did was send an email. As a commissioner, that was your right. You CC'd me on the email, and it was literally what happened to the lady tonight because she was escorted out. They sent the email back like, this is what happened. This was true. This wasn't true. And it was like, okay, thank you. And we left it alone. So that's what's like, there is an overthinking. There is some of, we're not thinking about the power we have and what our responsibilities is. You can definitely send an email and say, hey, last night, this person, when they made a public comment that officer so-and-so came to them, is there any record of that? That is a simple email. That's not
But can I use that to say like, oh, this email was sent, you cannot be recommended for this promotion?
why not?
Well, I don't know what that email is, but just in the context, that's just,
Because you're thinking about it from a civil, you're not thinking about it from what our actual responsibilities is as a community
I
police
am.
commission.
I just see it a little differently than you. I'm not sure that, so I'm not gonna say, I don't know that specific email and those details. But what it sounds like is that, I can't take that because I don't even know if we can share those details. I don't know.
But that's what I'm saying.
I don't
You
know.
can't. Somebody, Lou right now could ask for a public records request of every time we had a meeting in First District and see it. Everything is
Okay.
like, we're so afraid of being sued and legal that is impeding on us doing our job.
So what I'm saying, I don't think that's the case. What I'm saying is, I don't even know what's in that email, so I can't confirm or deny.
Literally, the email
But
just said
What
what
we
happened.
can, so what you're saying, based on what you're saying, is that you feel that we can use that to state that somebody can't have a promotion, be recommended for a promotion?
I think it's.
I don't feel comfortable with that.
Well, that's you. But we
Okay.
are a commission of 12 people,
Right.
12, 13
Right.
people. So if somebody in the community got up and said, I'm sorry, I had a very egregious experience with this officer, I think that it is within our right, one, to send an email quickly and say, have any of this ever been documented? I think, two,
Right.
it is within
So
our right.
to send them to
It is, I didn't
it's
say
a
that.
very
Don't
police
put words in my
report.
mouth. I didn't say
That's
that.
what I said.
That's what you said.
So I don't
My-
want to argue with you.
So
but go
my
ahead.
first thing is that I think it is within our right the next morning to send an email to whatever district they were talking about and say, have you guys ever heard of this? I think secondly, it is okay for us to instruct our staff and ask them, can you follow up with that person and find out? I think it is within our right to say before, like if we were gonna if this was Monday and we said on Thursday we're gonna let people know, I think it's okay to say, hey, this was a very important allegation. Jason, can you look into this? We, at this point, we will not make the decision on who we're going to choose until our executive director is able to look into this, OPS, to see if there's
So
even a
right,
valid
OPS,
concern.
like we said,
Yes, but I said
OPS,
that
so we
there's
cannot
more
make a
things you
determination. So we cannot make a determination based off that. So it has to follow proper
No, it doesn't.
procedure and protocol.
I didn't say
which
that.
goes to OPS.
You,
I can't confirm or deny that happened.
no, what Adriana, I'm not even going that far.
Okay, we're going with the same thing.
No, I'm not. I'm literally saying, one, if somebody says, Officer Black came to my house last night, okay, and we're saying we don't know if this is factual, I
We
can
don't know if it's
call,
factual.
I can call 3rd District tomorrow morning and say, is there any record of Officer Black going to Ms. Johnson's house? They can look and see and say yes or no. They say yes. This was the call. We then can ask Jason, hey, that was a really crazy complaint. Can you follow up? Because we have found out that we don't know what happened, but it seems that the officer was at Ms. Jackson's house.
Mhm.
He follows up. He says, it seems she has a complaint. Okay, tell her to go through the proper protocol. We can then at that point say, because of the serious allegations, on Thursday, we previously were going to release a list of people that we recommended, but due to new knowledge that we have found out, we are going to pause and allow for OPS to do an investigation before we release these new names. There is nothing biased about that.
So yes, they have to go through the proper procedure. So I don't know if we can make a decision based on promoting or not promoting based off that.
I said pause.
Okay.
That's what I
Okay.
said. I said you can
Okay.
pause it. But there
So
are
I don't
things
know-
you can do before then, and this is not in Charter 115. That's what I'm saying. Like, we're so worried about being sued.
It's not
That we're-
about being.
It's about being responsible and
Right.
being
That
So
is
we're saying not being
responsible.
So if there's a serious complaint, I agree that we need to take the proper procedures and protocol, which would be OPS, Civilian Police Review Board, right?
So we
So
will release our
ideally-
recommendations, knowing that
So
a person
ideally-
put that out.
Ideally, I wouldn't feel comfortable nominating that person. I would say there's a pending case or order.
Let's
in
pause.
But does that mean pause everyone? I don't think it means pause everyone. Maybe that individual, depending on what it is, because I don't know that email, so that's why I said I couldn't speak of the specifics. Go ahead, Maureen. But it wouldn't be, okay, so I just want to clarify, because we're on the record. A complaint comes forward, because that person says something, we will not take that candidate into consideration. That's not the case. What we're going to do is follow the proper procedures and protocols. And it's very important because we can get in trouble if we say, community member said A, B, and C, and we cannot confirm or deny, right? At this point at stage, we cannot confirm or deny any accusation that doesn't go through the firm and they verify the lawsuits or where they are, what's
I never
sustained
said
and what's
that.
not,
I gave
right?
3
So,
things that we could
right,
do.
right, so when it comes to the firm, right, and they do their research and their background, but when it comes to the community, we cannot confirm or deny any accusations. So
I didn't
it's
confirm or
being-
deny. I said we asked a
being-
question and
be
we
very
paused.
mindful, and we follow proper procedure, which is to go to OPS and the Civilian Police Review Board. So I can agree with that, but I cannot confirm to make any kind of decisions based on information. We don't have all the facts. They haven't went through their due process or even had any kind of
Adriana, no one said we denied them. I said you will pause the process because if a community member came up with an actual egregious action that happened, it is within our rights to ask a question to a commander. It is within our right to ask our staff and our executive director to look into that complaint. It is within our right to ask our staff and instruct our staff to tell them to follow the proper protocol. And it's within our right to say, hey, we know that we told you guys on Thursday we were going to give you a list. We need to pause because we need to make sure that this officer and what this community member said, that we know exactly what happened. That is, I'm saying you pause the hiring.
But I think because we're doing our due diligence, ideally we're gonna filter and then we wouldn't have in a perfect, but I think they might come, it's a possibility it may come. So I can understand if a claim comes, but I think we're trying to do it in the front end so that we know different lawsuits and things like that.
But I'm not talking about lawsuits. I'm literally talking about, I have been in situations, good or bad, with officers where an officer has came to my house. Maybe it was for a good reason. Maybe it was a bad reason. I could have turned in anything I want. I'm an honest person. Everything isn't always documented. We know that for a fact. If it wasn't, we would not have a consent decree in the city. If everything hasn't gone through the proper channels.
I do understand it. But what I'm saying is, if something isn't documented, can I use that in a promotion process?
And so what I'm saying is, I said you pause it until an investigation is done.
To the chair, we're
Pause it because the allegation has been raised.
to the chair though, we're to the chair.
He's gonna look into
We're
it.
trying to
So here's the thing though, the question of what people say, right? That's on you if you consider it. Agreed. You are both raising valid points. Should we or should we not consider it? But the original question still is, why exclude the community from speaking, right? So yes, we can run through a lot of what if scenarios, right? But I stand by what I said. You should give the community an opportunity to tell you what they just witnessed, good or bad. We're also assuming they're going to line up and just throw stones at our candidates. That may not be the case. You're also excluding from hearing positive things from the community by not opening that microphone, right? They may line up and say, overwhelmingly, they think one of these candidates is the greatest, right? And they just help you, feel that too. So you're excluding all negative and positive feedback of that moment. And I think most people will keep it in that moment. They will want to tell you about what they just witnessed in that interview. And it's not an obligation to use that information. To Commissioner Garrett Ferguson's point, you already have a background check, you have other information. So if you later changed your mind, even if you heard negative things, you can articulate why exactly you did that and let the chips fall where they may. The community may be angry or not. But you don't, by not allowing them to speak, they're going to find a way to make sure they're heard, except instead of speaking about that officer, they're going to speak about how you didn't let them speak, right? So just let them do it. We let them do it at every other meeting. So I just am not satisfied why we're deciding to cut it from this one type of meeting.
I don't hear anybody saying they don't want the community to speak.
Well, that was in here, is that there is no community comment period. That's what Commissioner Donaldson raised, is that we have excluded we have said we can't have community comment period after the interview. That's how this started.
Well, I'm not against the community speaking. I just want to make sure it's done responsibly so that we don't compromise ourselves.
But compromise comes from, the point I want to make is compromise comes from you and what you do with the information you hear, not by allowing them to speak, right? If you're compromised by what they say, that's because you allow yourself to be. It's not because you allow them to speak. We hear things that could compromise us at every single meeting if we choose to accept it. So the act of allowing the public to speak does not make the integrity of this process go away. It doesn't. It's only if you consider things that you shouldn't have, and that's on you. It's not on allowing the community to speak, right? So that's the line there.
Oh my goodness,
No, it was all.
I am loving all of this discussion tonight. This is no, really, this is so good. This is so good. Thank you all for all of these comments on what we've written here. And of course, there's no right or wrong answer. So I think that it's really important to also give ourselves some grace as we work through trying to find the answer that's going to work for everybody. So I thank everybody for that. In terms of why it's written this way and what my stance is on it, if anybody cares, it's obviously not material in terms of making an administrative decision, but this is why it was written. And why I wrote it this way was, obviously, you're able to have a little bit more control of what is being shown to the community and also what is being shown to the committee in terms of public comment if we capture it in a written form first, right? As we see, that was just evidenced by Commissioner Garrett Ferguson, the committee hears something at a public comment, and now suddenly they're sending emails, they're going down, they're chasing it, they're after that like a dog, right? They want to know more about that. Well, maybe that was something that was already vetted by the firm in the preliminary phase, and that was purposefully and intentionally excluded from being in front of the committee. I understand, and I agree with Jason, and I agree with Commissioner Garrett Ferguson, that ultimately is the responsibility of the commissioners to make sure that even if they hear something that may be biased in the long run, that they stick to their oath that they took to make sure that they're making unbiased decisions based on founded evidence and founded and claims. But the reality is you can't unhear something, right? You can't unhear something. They call and declare mistrials for that issue all the time. That once you hear something, even though in the long run you find out that that's not something that is going to allow us to make a decision based on it, you can't unhear it. So once you hear that information, it's out there, and you could possibly have made a decision based on it. And I think that we are also opening ourselves up to questions about whether our decision is based on that information, if we're allowing people to do public comment on the microphone, right? Now it's calling into question whether our decision was based on that comment. And obviously we can't stop people from making biased content, can't stop people from making biased comments on the microphone at all. So the intent of this was to say that we are spending a lot of time and effort to control the environment of documents and information that is coming to the committee in the background search process. Why are we not implicating those same guardrails during our actual interview process? But I agree. Ultimately, at the end of the day, it's on us to make the decision of whether we can trust our commissioners to make unbiased decisions, even when faced with extremely prejudicial information. So there's no right answer, but obviously as the attorney, I'm going to bank on the safer side than not.
So could bring it to the committee. Does anyone, I guess, want to put a motion for to change anything or?
She's asking, if I can jump in, she is asking whether the committee wants to make a motion to amend the public comment section of our policy to instead move from a written community feedback in a survey to a open public comment forum. And obviously, we're not discussing having the ability of community members to ask questions of the candidates, right? We're only saying they would have an opportunity to speak in public comment based on their comments. So they're not pointed questions to any candidate.
I'm looking at the other version, so I don't know where that is.
Okay, hold on. It's all over the place, so I'll have to amend that section with that idea. Here it says
I think it's under procedures.
community interview process.
I think that the middle paragraph,
Each community member take-
that last sentence.
Oh, and one other thing I wanted to say to Commissioner Garrett Ferguson's comment that she said earlier was that you said, if I can paraphrase you, and you let me know where you need to correct me. You said that nothing's going to stop one of the commissioners on the committee from bringing whatever questions they want to the interview process. But one of the parts of our policy is that the committee before the interview is voting on what questions will be asked at that meeting and which ones won't be. So just to clarify that, obviously.
So commissioners just can't ask them about it.
Exactly. But again, no one can stop a commissioner from breaking that policy, but they could be held accountable for it. So, where is this?
Right there.
We probably should put that in writing too,
Right there
that
in the middle.
any questions that's asked is not approved.
I think it's a given, but we
I
can.
don't know, I think we should put that.
Okay,
in.
that's
We can
fine.
put it in there, but again, I think that our history has shown that people don't follow rules if they don't want to.
But if it's written, you are liable for any repercussions that may result from it, if it any.
I'll make the motion.
Yes, here we go. Each committee member will take turns asking the applicant the questions, and the agenda for the event will not include any opportunity for public comments. So this specific section would just be removed, would be altered to say something along the lines of the agenda would include opportunity for public comments.
I move to have that section changed to say, that community comment would be allowed.
That's it.
for public.
No, you gotta take it out. Take it out.
Well, let's vote on it first, and then I'll make this, and then I'll amend it.
I don't get to vote anyway, so whatever.
Second.
Any further discussion or debate? Let's call for the vote. Commissioner Donaldson?
Aye.
Commissioner Garrett Ferguson?
Aye.
Commissioner Rodriguez? We'll vote no. Motion carried.
Okay, progress. Great.
I have another motion.
Okay.
I move that we actually end this meeting at 8 PM on the dot.
So I cannot make a comment.
Or, okay.
This is the last round, so I think we should do it after this. But we gotta move to extend it, so.
So we don't need to move to extend. We'll be fine.
To the,
Well,
to
who
the
wants to
chair
talk?
and Martin, did you need this to be voted to move forward to the full commission? this
Yes,
evening?
we do, because if you want, and I also would have welcomed direction on what we're doing next in terms of deciding to go with the firm or not, right? Or are we thinking that we have to have another meeting like this to talk about finalizing this policy, talk about what our next steps are, because I'm kind of a little bit lost on that.
For all fair, we started late.
I think we should just finish it,
Mhm.
send it so we can do it on Wednesday. Because we really have one more section that we can make a comment.
Well, no, we have one more section and we have to make this decision.
It's just one, it's like 2 paragraphs.
Okay, so this last section of the community interview, records release, everything released on the commission's website must be viewed, redacted and approved. We're talking about, in this section, that all the documents that we have seen up until this point, the committee will be shared on the website and redacted, so that way the public can have access to that before the community meeting. The committee will question the applicants with predetermined questions in front of a live community audience. The applicants will appear individually. The committee will make its best efforts to sequester the candidates so they cannot hear each other's responses to interview questions. Each committee member will take turns asking the applicant the questions, and the agenda for the event will include an opportunity for public comment. As so voted. However, the committee will distribute and then let's say the committee will, you guys also want to do community surveys too? Or just public?
Because people process information differently.
Do
So
both?
it's both, yeah.
Okay. After the event, the committee will score the interviews based on the interview scoring rubric and factor in any community feedback it receives. I would say, can I amend this? Obviously, that's done, is that we're not bringing in unlawful stuff to bias us. The final choice of a candidate for a recommendation to the mayor is a choice for the committee to make and should in no way be overridden by the community comment it receives. Final recommendation, the committee will meet one final time to discuss the results of the interview scoring rubric and to select a single candidate by a majority for its recommendation. The final score, which is a combination of the candidate's preliminary interview scores, will determine the committee's choice of candidate less any unforeseen significant circumstances. Once selected, the committee will make its recommendation to the full commission in its next full commission meeting. The committee must repeat the final recommendation process until it obtains a candidate approved by a majority of commissioners at a full commission meeting. The executive director will communicate the recommendation to CDP and the candidate once approved by the full commission. So I think the last part is sort of painless. We're saying that our final recommendation is going to be based on the final combination of the scores. And then we'll have one final candidate to recommend.
That sounds good to me.
Okay, great. So how are we feeling about we did not go over the other policy.
It's the same.
It's the same thing, but just imagine that the person doing this background search process is an internal person versus a third party. So we're feeling good about the outside contractor, it sounds like. Is that a unanimous decision?
I think so.
Yeah, I do feel good about that. I just want to clarify that we would go to that firm and ask, like, for specific parameters that we would kind of set what we need or what we're looking for, right? Because the other policy mentions social media, but that's something we would get through the firm.
Yes,
Okay,
we would specifically include that in the scope.
got it. And then the part about that we changed when you added lawful community feedback factoring in, but then the next sentence says should in no way be overridden by community comment it receives. I'm just trying to make sure that that's clear to me, because so we can factor in lawful community feedback we receive with our scoring rubric, but then that our decision can't be overridden by the community comment we receive. Like, it seems like it's.
No, so let's read it here. After the event, the committee will score the interviews based on the interview scoring rubric and factor in any lawful community feedback it receives. The final choice of a candidate for recommendation to the mayor is a choice for the commission to make and should in no way be overridden by the community comment it receives. So the intent of that sentence is that we understand that we're going to be needing community comment, but this is a decision for the committee to make and the commission to make. You know, we can factor in public comment and community feedback, but it is our decision. So I don't want the community to read this policy and be like, well, that's not who we said or who we voted for. They should be able to understand that this is our decision.
Right.
We can reword it if you have any recommendations.
Not really any recommendations for this part, but I guess the scoring rubric is what I'm thinking. Like, we'll have to figure that part out later.
Yeah. Okay, so unanimous vote for going for a third party background check firm.
And if there's any kind of barriers or complications, we can always have the other policy as a backup, because, you know, we're navigating this and it's a lot of unknowns, right? So.
Okay, and do you want to do an RFP for your own firm, or do you want to pursue seeing if a contract exists with some other, with either with HR or with somebody else, to join with them. What are your thoughts?
So I think it depends, but I think because of time, if there's an existing contract that we can hop on, I think especially for this first time, that might be beneficial. And then probably put a RFP for like a contract for like, hopefully maybe like 5 years or something.
I would agree with that, except for the fact that I feel like we almost get to a point where we could RFP and contract faster than trying to get solid answers out of people and then like fighting with them to join their contract. I don't know. There's been a couple of instances recently where we've been like, yeah, the existing contract, let's go figure that out, jump on it, and then that ends up being
Being
like,
longer.
being longer because we're waiting for that person to respond. We're not talking to the right people. They're like, okay, but maybe if you do a contract amendment and maybe the terms of their contract don't exactly match with what our policy is. So maybe an idea would be to say, we'll pursue trying to join a contract with somebody else for so many days. If it's not fruitful, then we start our own RFP process because realistically,
Days, what time?
yeah, because we want to get this moving, right?
Especially 'cause it's been a
Jason,
while.
how do you feel about that?
Well, this one has a little more simpler track. If all you guys have to do is say, we want this to be affirmed, if it's not over $10,000, which I don't think it will be, we don't have to come back to you. You just let us do our job. Because the only reason that we've brought other RFQs forward to the commission for this complex approval process is because there is a standard in our rules that says if it's over $10,000, we have to go through this longer approval process. If it's already money that is appropriated, and we do have money appropriated to contracts, right? And it's under $10,000. Once you say we want to do this, staff is empowered to do it. So just Martin and I will handle it. All we need to know is, are you okay with us doing the firm thing? And I think once we answer that, we're ready to go forward. So yes, if you want to put a day limit on it, I know we need to move this forward. I'm not going to delay in any way. So my calls will be, do we have contracts? Can we get a contract? No, let's do our own.
Okay, so my question is, if there's any difficulties with, you guys would just make decisions, or would it come back to the committee? Would we have to schedule a meeting?
I don't think there would be any difficulties. I mean, either we're gonna find an existing contract or we're gonna post an RFQ, but we don't have to post the RFQ. All we need is this to happen. If you guys agreed that you want to use a firm, then Martin and I can start working on that. The logistics of the RFQ will work with you, Chair, on, the specifics of the provision for the exclusion or non-exclusion to make sure it's okay. But,
And then the last thing I would say is I do ask for a motion to approve the policy with the changes we discussed today, so that way we can move this policy up to the full commission at the meeting on Wednesday.
Before that, one quick thing. So under section or step 2, background checks, can we just add a sentence saying that the committee will provide this to the firm, just something?
yes.
Like that. Committee provides, like that, the committee provides the scope of the background check to the firm for contracting purposes.
Yeah, that's perfect. Thank you.
Motion to approve?
I move to approve the policy recommendations for PPEC with the amendments that were provided during the committee meeting.
A second.
Unanimous.
Any further question or debate?
Public comment.
No? Okay, we're gonna call for the vote. Commissioner Donaldson,
Aye.
Commissioner Gary Ferguson,
Aye.
Commissioner Adriana Rodriguez, aye. Motion carries,
Thank you.
just for the record.
Great, thank you. I'll share the updated policy with you, Chair, and then you can motion for it at the full commission meeting.
Okay. And real quick before public comment, I just want to say, great job to you and Martin for doing this and slowing the process and just making sure that all of these legal questions are answered. I think you did a great job as chair, just taking the lead on that and working with our legal counsel to get
Thank
something
you.
really complicated done, so nice work, Chair.
Thank you.
All right, can you hear me?
You can't believe, I don't know if the public.
It should, try that one, Lou, just use the two.
All right, Lou, with unpopular comments. One thing important, we all know, the reason people with a low turnout, voting turnout rate, as a city, Cleveland has always been, why issue 24 had a high approval rate to pass. Because right now, this particular entity, this commission probably will be the only one people would put some energy and effort thinking that the possible positive scenarios will happen to people. One obvious thing will be people's voice can be heard. Up to this moment, it seems like only this particular entity, which is true, I can vouch for that, we will have a more opportunity for public input. Yes, not all of them will be straightforward, unbiased, true. However, I will use the last meeting of last year to be an example. We had different people from different districts to come up to present the information from their district. At this time, I could hear from the audience all the, not exactly whispering, but you know what I mean. All these higher ranked officers, it seems like they all have different reputations to deserve their promotions to begin with. So I definitely applaud that you will try to maximize the possibility of public inputs. Even very recently, I had to file OPS complaint. And this is the reason why it's important you allow public comments verbally, because we do have a digital divide. We do have illiteracy rate to worry about. That's why lots of people, they don't like to write things down, and they don't have a means to send information electronically in. Coming to the meeting to raise a voice could be their only chance to vent or to even get justice. That's what people expect you to come up with for the whole community. So maximize any opportunity to include public input with multiple channels are very important for you guys to do for almost each and every processes you have to go through. Because right now you are set up the policy for the future. So please continue this great action. Make sure you can incorporate public comments in every possible way, in every aspect. We do not want to have more officers giving negative experience to our residents to get promoted. We want the good officer to get promoted, the one actually helping people. So don't worry, people will only come to the microphone to tell you whatever officer ABC did something really horrible to me or to my auntie XYZ. You may also hear good stories too. So think about that. This is one important aspect. I wish we can have this in all other committee as well, when they have to go through certain policies to their field. The other thing, let's step one back. Today, I cannot say our discussion in this meeting was not heated. However, you guys did not really use that to say one particular commissioner intentionally to pause or to drag the meetings longer or to let the motion not get passed. Today, if you don't do that, then that means you understand heated discussion sometimes is necessary. So please apply this to all commissioners. Do not exclude any commissioners when this commissioner has a different point from what you have been worrying about or what you have been thinking about. Otherwise, you are not actually doing the diversity, the inclusion yourself. Please understand, this is also very, very important to the community. We need to take care of every little bitty points in a policy, yes, but we also have to make sure every little bitty points will make our bigger picture coming up better and sooner. So please do not consider any commissioner is trying to stall a meeting, trying to delay a meeting, trying to create arguments just for the sake of having arguments. Thank you.
Thank you so much. That's gonna be our conclusion of our meeting at 8:16 p.m. Thank you and have a great night.